an LLC or an S corp, you do have the same issue. Generally, if it gets to a personal guarantee, they're also going to collateralize that debt with your interest in the LLC. So once it's secured, you don't have the asset protection of the membership interest. If it's unsecured, they can come in and take it. But once you've offered it as collateral and you default on the loan, they can come in and step in and take your interest in there.
Stu, did you say that you could have the LLC and elect S corp status?
Correct.
Within the LLC, and that simple check the box eliminates the Medicare issue?
That's correct. That's correct. As long as you take out the excess income as distributions as opposed to a salary. Exactly. All right. Let's talk about trust accounting and the new trust code. Florida, again, it was interesting the way that this legislation went in. Let me digress for 1 second. They passed the new Florida trust code in 2005, and it didn't come into effect until 2007. So that gave everybody a long time to view it and digest it. They made some modifications in 2006 to the trust code, but basically what ended up happening is in 2007, July, it kicked in, and notwithstanding the fact that everybody had 2 years to look at it, it was still eye-opening for a lot of this stuff, and there are still a lot of unanswered questions at this point in time. All right. Let's talk about the things that it impacted. It impacted trust creation, representation of beneficiaries, modification, the powers that a trustee has, revocable trust, and their duty to inform an account. Let's talk about creation. A trust used to be able to be created and executed in the same manner as a contract. A couple of witnesses were fine, or a notary was fine, and that was it. What the new law says is that if it contains testamentary aspects, meaning it's an irrevocable trust or it's a revocable trust that's designed to have impact after the death of the person creating it, then it must be signed with the same formalities as a will. And that is 2 witnesses and the person creating it, the grantor, in the same room, each attesting that they saw the other one sign. And if you want to avoid having to prove it up in court, it needs to have a self-proving affidavit, which all 3 again sign before a notary saying, this is what we did and we all signed this. Okay? So that changed. Under the old rule, a trust didn't have to have that. Under the new rule, they do. Also, any trust that contain real estate now must be in writing. There is a provision for an oral trust where 2 people can have a trust just by talking it through, but if it's going to contain real estate, it must be in writing. All right, representation. This is very, very interesting. Each beneficiary of a trust is required to have representation for accounting and distribution purposes. The grantor is now permitted in the trust to designate who the representative is for certain disabled or minor beneficiaries, and service is now permitted to be given to that particular person as the representative of that minor or disabled child, minor or disabled beneficiary. And they can name the parent, the grantor can name anybody that they want. And so from an accounting standpoint, now you have a person to serve that accounting on for those disabled or minor beneficiaries. Okay. There's also, the trust law also completely changed the way you can modify trusts. We were very restrictive here in Florida for what was called non-judicial modification, meaning the beneficiaries, the trustees, couldn't all get together and make a whole lot of changes to the trust document after it was executed. Under the new law, the amount of modification that those people can do has broadened significantly. And now, if the grantor is alive and the trustees and the beneficiaries could all get together and make substantial modifications to the document without having to go to court, as long as everybody signs off on that, and all the minor or disabled beneficiaries' representatives sign off on it. it makes it a lot more flexible. It's the save the lawyer provision, basically. If the attorney didn't do what they were supposed to do, now everybody else can get together and save them from themselves. We don't ever require this in our office, just so you know. All right. Also, we have expanded trustee powers. Now, even if they are not mentioned in the trust, so long as they're not withdrawn from the trustee in the trust, there is a large list of additional powers that the trustee has by statute. And it helps out a lot because what was happening before is that especially in sales of businesses, real estate closings, IRS issues, if the trust didn't specifically designate certain powers, you ended up having to go to court and there were tons of issues and they delayed or canceled transactions. Now, statutes contain certain powers that every trustee has, notwithstanding what the document says, unless they are specifically withdrawn. Revocable trusts. An interesting assumption in the statute that unless the trust says that it's irrevocable, all trusts are deemed revocable. So when you look at a trust or read a trust, if it doesn't say it's irrevocable, by statute it's going to be revocable. And yes?
Are this all for existing trusts or everything that's in existence is grandfathered in?
Some of this stuff goes backwards, some of this goes forward. The assumption on revocable trusts is a forward from July 1st, 2007 going forward. The modifications actually start a couple years before that. Not for all trusts, but there's a particular date in the statute going forward. And then there are some that just go back all the way. Okay? So, again, unless it says it's irrevocable, it's revocable, and while the grantor is alive for a revocable trust, the trustee owes no duty to anyone else, requires no accounting to anyone else other than the grantor. Okay. This is the most significant change